Again, my name's Adam Foster. I'm the Executive Director of Texas Alliance Groundwater Districts. We are a nonprofit membership organization. Currently, we've got 91 of the 98 groundwater conservation districts as members. We also have about 45 associate members, and they make up groundwater professionals, lawyers, consultants from around the state. Basically, anybody who is invested in groundwater management, groundwater science can be members of our association. And I'll talk a little bit more about our association later on. I appreciate the opportunity to come and talk about groundwater management today, especially to this group. It's actually one of my other passions besides groundwater is native plants. So I don't do as much gardening as I used to do, but hopefully one day I'll have the time to get back more into it. But I appreciate all y'all's efforts, and I am of like mind when it comes to native plants. So I'm going to give an overview of groundwater policy in Texas, kind of the history of how we got to where we're at today, and then talk about what GCDs are, what they're required to do, and then how they also serve the people of Texas in their day-to-day functions and some of the other stuff that they do besides groundwater management. We'll talk about districts themselves. We'll also talk about the joint groundwater planning process and how that feeds into the regional water planning process in Texas, and talk a little bit about the state water plan, which is all very, very important when we're talking about groundwater management, because the state has a bottom-up approach that really focuses on local needs. In other states, Texas is kind of an outlier. Most states have a top-down approach where the state is telling the local areas how to manage groundwater, where in Texas we have a bottoms-up approach. So we'll talk a little bit about that as well. Groundwater policy in the state all started back in 1904. And essentially what you had was, it started with the East Case in 1904, and essentially what happened was there was a farmer up in North Texas. He had a well that he had been used for years to irrigate his fields. And next door, the railroad company, the Houston Railroad Company, came in and they drilled a much deeper, larger well and started a pump. Eventually what happened was it drained Mr. East's well. And so, like any, Texan, he said, well, I'm going to sue my neighbor for damages because they drained my well. So basically the case made it to the Texas Supreme Court, and the Texas Supreme Court in this case ruled that essentially that there was no liabilities for the railroad, right? His only remedy was to drill a deeper, larger well, okay? And so that kind of set the stage for policy and groundwater policy in Texas for about 50 years. And what it basically said was Texas is a rule of capture state, AKA the law of the biggest pump. And what it says is landowners have the right to capture an unlimited amount of groundwater beneath their property without being liable to their neighbors. Okay. So why did they adopt this rule? In their judgment, the judges says the existence, origin, movement, and course of such waters are so secret, occult, and concealed that an attempt to administer any set of legal rules in respect to them would involve hopeless uncertainty and would be practically impossible. And at the time, that was somewhat true, right? They did not really fully understand groundwater, how groundwater moved, how much water was in aquifers. This was over 100 years ago, and obviously the data and the science that we have now, we have a very, very good grasp of our aquifers in Texas, and we'll talk a little bit more about that later. So obviously there's some limits on the rule of capture. The first being trespass. You cannot trespass on your neighbor's land to drill a well, nor can you drill a well at an angle and suck up the water underneath your neighbor's land. You cannot drill a well for malicious intent, meaning you can't just drill and pump a well just to pump the well, right? You have to use that water for a actual purpose, a beneficial purpose. Another limit is waste, so you can't waste the groundwater, and that gets into a whole sticky legal topic about what is actually waste, because one person's waste is obviously, you know, not somebody else's. I mean, I think people in this room may think that, you know, if you're watering non-native plants, that's wasteful, right? But it just all depends on what you can prove in a court of law. And then the last one is subsidence. So in some areas of the state, if you pump huge amounts of groundwater, you can cause the land to subside. And we see this primarily in the Houston-Galveston area, but there are some other areas in the state where this can happen. It typically requires, again, large amounts of water to be withdrawn to actually cause subsidence, but it has been documented in the state of Texas. So the rule of capture was basically in place for about 50 years. And throughout this time, you know, Texas experienced a lot of droughts, a lot of floods. This whole rule of capture caused a lot of issues. And then in 1949, the legislature finally got involved, and they decided that they needed to take a closer look at how groundwater is managed in the state of Texas. Another thing I want to point out that I didn't mention before is that the rule of capture set a precedent that landowner owns the groundwater underneath their land, which is very different than surface water in Texas, which is owned by the state. Okay, if you want to take any water from a body of surface water in the state, you have to go to the state and get a permit to do so, right? That's not the case for groundwater. So coming back, 1949, especially up in the Panhandle, they were having a lot of issues with drought. A lot of farmers were getting upset, and so the legislature decided to take a closer look. And what they came up with was this idea of a groundwater conservation district. And they are local entities that would control the management of groundwater, right? They were all designed to be locally tailored to local groundwater uses and needs in that area. And one of the comments made by the lead author at the time was, if I favor no control, but if we must have it, let it be local. So this went on for about 45, 50 years. Throughout that time, we saw the creation of about 30 districts from around the state. Then in 1997, as the state was growing, they decided to take an even larger look at groundwater. And they came up with Senate Bill 1 that was passed in 1997. And this established that GCDs are the state's preferred method of groundwater. And it created much of what is in Chapter 36 of the Texas Water Code, which is the chapter that basically deals with groundwater conservation districts. So here's a chart showing the formation of the 98 groundwater districts. So as you'll see, throughout the 1950s all the way through the 1980s, we had about 20 districts form. And then in the 80s, we started to see a few more. By the end of the 1980s, we had 30. And then we just had an explosion in the 1990s and the 2000s, right? And since 2009, there's only been 2 additional groundwater conservation districts created. So currently there are 98, and I'll show you a map here in a second of where all those 98 are. One thing to clear up, there are also 2 subsidence districts, the Harris-Galveston subsidence districts and the Fort Bend subsidence district. There's also the Edwards Aquifer Authority. A lot of people think those are groundwater conservation districts, but they are not. They are set up differently. They have different enabling legislation. They don't necessarily are bound by Chapter 36. They have similar authority and rules, but they are not technically groundwater conservation districts. And they are members of TAG. So what is a groundwater conservation district? Essentially, it is the state's preferred method of groundwater management in order to protect private property rights and balance the conservation and development of groundwater to meet the needs of the state. They are political subdivisions of the state. They are created by the legislature, and they have powers expressly granted to manage groundwater in a local area. They're explicitly defined by the legislature. One thing to point out is they are not water providers. They do not sell water. All they're there for is to manage a resource. A lot of people get confused between water suppliers and GCDs, but GCDs are not water suppliers. Water suppliers come to them to get water or to get permits for water, okay? So, districts have a very challenging time managing, because in Chapter 36, they are essentially told that they need to allow for the highest practical use of groundwater production, all while conserving and protecting and for the recharge of the aquifers, right? And you're also trying to balance private property rights with all of this. So you're constantly thinking about private property rights when you're issuing permits or you're deciding on who gets to withdraw and how much they get to withdraw. So and many times it can be extremely complicating scenarios, and depending on where you are in the state, how many people live there, it can even be more challenging. So there are 3 ways that a district can be formed. The first is by the legislature. Essentially, a legislator will file enabling legislation that will create a district. It'll outline the boundaries of a district, outline how the district can be managed or governed, and then also typically how it will collect funding, so the funding mechanism. And we'll talk about funding mechanisms here in a second. This will typically require confirmation election by the locals. The second way is by TCEQ initiation, and we saw many districts in the 1990s and early 2000s formed in this way. And essentially what TCEQ does is they identify an area where there's no groundwater management in the state of Texas, and they obviously see a need for groundwater management, right? There's a lot of people there, there's a lot of uses going on, and if there's no management of groundwater resources, they can list that area as what they call a PGMA, or a priority groundwater management area, okay? And then once that PGMA is established, then they can also outline the district's boundaries, how they're going to be their funding, and then that goes to the local voters on the confirmation election. And then lastly, which was what we've seen mostly since the early 2000s, is by landowner petition. And so this is in areas where there's not a district, the landowners can bound together, and if they get enough signatures, they can petition the TCEQ to form a district. And again, it still has to go through a confirmation election to be confirmed by the local people. There's actually one that was just submitted last month in Nueces County. So it doesn't happen all that often, but it still happens. There were a few that they tried to create in the early 2000s in Northeast Texas, and those weren't unsuccessful. They were petitioned, the TCEQ was petitioned, but ultimately it was voted down by the voters. So we have 2 maps here. On the map on the right is the 98 current groundwater conservation districts. And again, the subsidence districts in the Houston area and the EAA are included in this map, but they are not, again, GCDs. And I apologize for them being this small. I would have made them on separate slides if I had known that it was going to be this small. So, but the one thing I want to point out, and you can see without getting into too much granular detail, is that they overlay pretty much the 9 major aquifers of Texas. So Texas is blessed with the amount of aquifers that we have. We've got 9 major aquifers and about 23 minor aquifers throughout the state. And basically what the definition of a major and minor aquifer is a major aquifer can produce vast amounts of water or large amounts of water over a large area, and a minor aquifer is either a small amount of water over a large area or a lot of water over a small area, okay? And the 23 or 24 now, I'm sorry, minor aquifers are not included on this map. But you can see 2 of them, The Ogallala, which is in the panhandle of Texas and stretches down into the Midland area, and the Gulf Coast aquifer that extends from actually down into in Mexico all the way to Florida, are two very prolific aquifers. The Ogallala actually goes all the way up into Kansas and over to Colorado, and 80% of the U.S. Ag production comes from the area that overlies the Ogallala. So lots of groundwater use. Panhandle is a arid area, so the vast majority of water in those ag areas are from groundwater, right? And we have seen groundwater withdrawals in the Ogallala over the past 100 years. It's getting better with management and new technologies as far as irrigation, but the Ogallala is, they call it managed decline. So there's really not much they can do as far as management other than just try to slow it down as much as possible. Gulf Coast, there are numerous large cities that rely on the Gulf Coast aquifer, include Houston, Victoria, Corpus Christi, and then you've got Brownsville and Harlingen area down along the border. So a lot of uses as for the Gulf Coast as well. And GCDs cover 175 of the 254 counties, and they overlie approximately 85% of the aquifers in Texas. Anywhere you see white on the map on the right does not have a district, and the rule of capture applies in those areas. So some information on districts. So funding mechanisms, whenever they're set up, and their enabling legislation usually details how a district will be funded. It can be either through property taxes, like ad valorem taxes, or production fees. So that you only have to pay when you're actually producing water. Approximately 2/3 are property tax based, and then about 1/3 is production fees based. There is a limit on how much a district can get for production fees. It's set at 50 cents per 100 or 10,000 gallons of water. Most districts fall well below that, okay? On the governance side, 70% are their board of directors are elected, and then 23% are appointed, typically by the commissioner of the county or the judge, and then the 7% are both, or some combination of the two. Composition-wise, and I apologize, the numbers didn't come through, about 2/3 are single county and 1/3 are multiple counties. So, powers and duties. I'm going to give a brief overview of the powers and duties. I could spend 2 hours talking about all of this stuff, but I just want to give you a high-level overview. So the biggest thing is they adopt a management plan, right? We're going to talk about planning and desired future conditions later, but each district has to have a management plan that has to be reviewed and updated every 5 years, and that outlines how the district is going to manage the resources under their control, okay? They participate in joint planning and adopt DFCs, which we'll talk about here in a minute. They adopt and enforce rules to implement their management plan and achieve their desired future conditions. They regulate using Chapter 36. There's a whole list of things that they can or may do to regulate groundwater, including permitting, fees, all that stuff is in Chapter 36. And then lastly, they can issue permits, register wells, and then ensure the proper drilling and completion of water wells. So a little bit more about the management plans. This defines the district's management goals. They also identify performance standards on how that management is going. So like any good business, you know, you have to have an outline or a plan of how you're going to manage what your resources are. And again, they're required every 5 years to come up with these management plans. Some are extremely detailed, some are not, just depending on the district and what the uses are within those districts. They are required by Chapter 36 to use the best available science possible, right? And we'll talk a little bit more about this later, but they get a lot of help from the Texas Water Development Board. They're the ones that run the models, and then depending on the district itself, if they've got additional funds, they can put towards local science and data gathering outreach. And then again, public participation. So every 5 years, they have to come up with new management plans or update the management plans, and the public is encouraged to participate in that process. So regulations of wells. The state of Texas, the Texas Department of Licensing and Regulation, they oversee the construction of water wells, right? They set the minimum standards for how a water well is constructed in the state of Texas. They also license and regulate the water well drillers and the pump installers. On the GCD level, they have the ability to require additional construction steps. They can make the construction standards more stringent. They can't make them less stringent, but they can, you know, if there's an area within the district that they know there's groundwater contamination or some other issue that would require some additional construction standards, they can put those in their rules. They can have production of on metering and reporting requirements. We'll talk a little bit more about that later. And then any type of well that goes in, whether it's exempt or not exempt, would still require a well to be registered with the district. And that is very important now more than ever because there was a bill passed this past session when somebody comes to apply for a production permit to a GCD prior to this past session or prior to September 1st, the only thing that they had to look at was other permitted wells within the district and how that new permit would impact the existing permitted wells. Now, with this new legislation, if you have a well that's registered, they have to take that well into consideration when issuing any new permits, right? So it's very important, this is my little plug, that if you've got a water well, make sure it's registered with the district. This is just some information outlining why we have well spacing requirements. So here's an example. You've got an existing well. If somebody puts a well too close to it, there's the potential that that well draws down the water level around the area and then sucks all the water from the shallower well, right? This is why districts have spacing requirements. It's because they want to make sure that there's no interference from well to well. Like, so when you go to apply for a permit to a district, they look at how much well or how much water is actually going to be withdrawn. They know how the aquifer, hopefully how the aquifer is going to respond to those withdrawals. And so they set distances from how far wells can be from each other, okay? You want to protect existing wells. And they can also put limits on capacity as well. So again, production limits, they can limit the volume or the rate. These can be based on acreage, so how much land a landowner has. Some districts have what they call correlative rights, and it directly ties the amount of water that you can produce to how much acreage you have, right? Implements limits to achieve the managed depletion. They have to preserve historic use. So one of the things that has been a very hot topic in the groundwater world is historic use permits. So if you've got somebody that's got a permit that they filed for 20 years ago, they take preferential consideration when you're talking about newer permits, okay? And that's something that's expressly said in Chapter 36. If it's a retail water utility, they can also take into consideration the service area of that retail water utility. So if it's a smaller utility that's only servicing 1,000 people, they may get less water than if it's a utility that is servicing 10,000 people, right? Or the city of, say, Bryan, okay? Those are some of the things that they can consider when looking at production limits. And then also, which is very important in this area, they can adopt different production limits for different zones within an aquifer or even within the GCD. So a lot of times you have districts that will overlie or have authority on multiple aquifers, okay? Especially in East Texas, this is the case where at any point within the boundaries of a district, you know, if you drill a 1,000-foot well, you may drill through 4 or 5 different aquifers or 4 or 5 different zones within an aquifer, right? And they can have production limits specific to each aquifer in each zone. Now, obviously, they have to have the science to back up those production limits for each aquifer or zone, but they have the ability to do that. And the local groundwater district here, Clearwater, has done a really, really good job of identifying how much water can be produced from each aquifer or each zone that can maintain you know, water levels in those various zones or aquifers. And a lot of districts in the Hill Country are going this way. A lot of districts in North Texas are going this way. So it's really great that they have the ability to do that. One of the things that I wanted to talk about was exempt versus non-exempt. This comes up all the time. So districts can only regulate non-exempt wells, right? Statute says if the well is exempt, then there is no requirement from a GCD, right? You don't need to require production, you don't need to require a permit, none of that stuff. So Chapter 36, there's 3 different kinds. If you have a domestic and livestock well, and it's on greater than 10 acres and can only produce 25,000 gallons per day or less, it's exempt. And then oil and gas drilling exploration wells are exempt. And then finally, surface mining wells are exempt, right? So those are all outlined by Chapter 36. And then in addition, a district's board can also set what the criteria are for other exempt wells. And most districts do this, right? They're going to exempt smaller domestic wells, or if you've got an ag well, they may exempt that. I don't know what the local exemption rules are here, but like some of the districts just north of here, that's the case. Like if you have a domestic well, they're not going to worry about you. They still want you to register their well. They'll still require you to register their well, but they're not going to permit it or anything like that or limit production from those types of wells. So just to recap, kind of districts and, you know, groundwater law in Texas, landowners own the groundwater beneath the surface. Landowners are entitled to drill for and produce groundwater, but not a specific amount. No district in the state of Texas can deny you a permit. They can limit the production if it's a non-exempt well, but they cannot deny you the use of that well, right, or drilling of that well. They can limit or prohibit drilling based on spacing or tract size and regulate production of groundwater. And then also, this is very important, GCDs can be liable for takings claims if the regulations go too far. But in a lot of cases, we don't know how too far is. And so, especially now, you're seeing more and more cases as Texas is growing, more people are coming here, they're relying more on groundwater, you know, districts are having to curtail pumping or limit permits, and so we're seeing a lot more takings claims and testing how far districts can go in court. Yes?
How do they actually limit the production? Do you meter it a well?
Yeah, we're actually going to go about the next slide, but yeah. So, oh wait, no. It was here, right here. So the well permitting requirements, so they can set production limitations and spacing requirements. So if it is, oh, I apologize, I have to repeat the question. How do districts limit the production of wells, correct? Yeah, so they have the authority in Chapter 36. So if somebody comes in and applies for a permit and they say they want to take X amount, the district is going to look at existing users in that area, see if the production is going to impact any of those wells. They're going to look to see how much water is available, and we'll talk about DFCs and MAGs here in a second, and compare that, and then they can either grant the full permit or they can say, well, you can't pump that much, but you can pump this much. And this is only for non-exempt wells, right? If it's an exempt well, they can't say anything, right? You can pump as much as you want. over here. Okay, so compliance and enforcement, Chapter 36 gives them enforcement abilities. So if somebody does over pump, right? So if they're permitted for a certain amount and they go over that amount, the district can fine the landowner for over pumping. They can also, if they determine that the water was wasted or not used for beneficial purposes, they can sue the landowner or fine the landowner. They do have entities that go out and check wells to make sure that they are legal. So again, the Texas Department of Licensing and Regulation regulates water well construction, and a lot of times districts are the first ones to find out about illegal wells, and then they'll report them to TDLR, or they have the ability to go after the landowner as well, right? But this doesn't really happen that often. There's only a few districts that actually have the personnel and the resources to do that. Most of the time, if they hear about an illegal well, they just contact the state, and the state comes in and determines if the well was drilled legally or not. They have authority over abandoned water wells, which basically an abandoned water well is a well that is no longer in use, right? So if a landowner has a well, they're not using it, it's not capped, it is an abandoned water well. And in a lot of cases, these abandoned water wells are a threat to groundwater resources, right? So the districts do have the ability to require the landowner to cap and or plug the well. And those powers are granted specifically in Chapter 36. If it is a deteriorated water well, a deteriorated well means because of its condition, it is causing detriment to the aquifer. It is causing contamination, or it is causing cross flow within aquifers or different zones that the well is penetrating. And then they have the reporting and metering requirements. Again, you asked, how do they keep track of it? They can require metering and production reporting every month or quarterly or yearly, depending on the district. And if they don't report that or they go over, then there's a possibility that the landowner or the user will be fined. And then non-payment of fees as well. So that's all what districts can do, what Chapter 36 gives them authority to do. Now I want to talk about the joint and regional planning process. And this is a huge function of what districts are there for, and they spend most of the time with spending their resources on this process. So again, as I outlined before, Texas is a bottom-up approach to water planning. Districts in groundwater specifically are managed on a groundwater management area basis. There's 16 of them throughout the state, and there's a map here showing the location of the districts, and you can't really see it that well, but the 16 are essentially overlay the major aquifers in Texas, right? And so they group the districts within a GMA, and the districts within the GMA come together and they set desired future conditions. Desired future condition is an expression of local groundwater management that provides a snapshot of what a specific aquifer will look like at a specific time in the future, right? These may be expressed in a variety of ways, such as water levels, drawdown, spring flow, or storage volume, right? So they come together as districts within the GMA, and they decide what they want the aquifers to look like, how much water they want in those aquifers at a certain period of time in the future, right? And then once they have that desired future condition, they send that value or those numbers over to the Texas Water Development Board, and the Texas Water Development Board uses groundwater availability models to come up with a modeled available groundwater. And this is the amount of water that may be produced from the aquifer each year to maintain that DFC, right? And again, these are determined by the Texas Water Development Board using these large groundwater availability models. Yes?
We have some sort of other method that, for example, cities, that we usually get our utility bill from for water.
Correct.
Do they have a place in this conversation somewhere? Planning for their population growth or
the question was, are cities involved in the planning process? Yes, in the regional water planning process, they are. But when it comes to specifically groundwater management and groundwater planning, they do not. So we'll go over this here in a second, but districts take that into consideration, but they are not directly, cities and counties are not directly involved in those management decisions or those DFC decisions. So whenever districts are coming together for the DFC process, there are 9 factors that they have to consider. First is aquifer uses or conditions. What are the existing aquifer uses currently right now? What are the projected uses going forward, right? So they look at, say you're in East Texas, right? So you got a lot of ag, you got some water supply companies. That's what's going on right now. And then they kind of project out and see, well, where are people moving? Are a lot of people moving to East Texas, right? So they're gonna take that into consideration when they're planning the DFC. This ties into the state water plan, how much the state actually needs. That's one consideration. Hydrological conditions. How much water is actually recharging the aquifers? They have a pretty good idea. I mean, it's not an exact science, but we're getting better at this, you know, out of state and on the local level, how quickly our aquifers are recharging. But we know how much is down there. We know how much is, in theory, is being pumped, and we know how much is recharging, right? So that's one consideration they take in the DFCs. Private property rights. They have to consider, you know, denying a permit or limiting a permit. They have to consider that you are denying a private property right, right? So that is a consideration that they must take. Impacts on subsidence. Again, there are some areas of the state where subsidence can be an issue, so that's one thing that they have to take into consideration. Socioeconomic impacts. This is one of the most complicated factors that they have to consider, but essentially, you know, how is withdrawing water from an aquifer going to have an impact on local businesses and people within those communities, right? Is it going to benefit them if you withdraw water, or is it going to benefit more the people that are receiving the water, right? So it's one thing that they have to take into consideration. Feasibility of achieving the DFC. This is an important one, right? So they want to set a DFC that is actually achievable. If it's not, there's no point in setting that DFC. Environmental impacts, another important one. So especially when we're talking about base flow, a lot of water and surface water in rivers and streams is actually base flow that's coming from aquifers that's discharging to these streams. And so they want to take that into consideration as well. They want to maintain those levels to make sure that there's enough water and surface water to, you know, help with the flora and the fauna that rely on that discharge and the people that are receiving the surface water down below. And then any other relevant information. And again, that's the DFC process. Then it's sent to the Texas Water Development Board, who uses the groundwater availability models to then send back a MAG, right? And then they have to manage to that MAG, that modeled available groundwater. This is kind of outlining the DFC process. It's 5-year cycles. We're currently in the 2027 cycle. So there are essentially 5 different levels within the DFC process. We're currently in the second one. So all last year, all the districts were getting together on the GMA level, and they were talking about the current groundwater conditions, looking at expected growth and expected water needs in their area. Right now, we're in the process of voting on those proposed DFCs. So if you were to go to any GMA meeting throughout the state right now, most of them would be voting on the DFCs. Once the DFCs are voted on, it goes back to the individual district, and it allows for the public to make comments on those proposed DFCs. Usually that gives about 6 months to 9 months, enough to get those concerns in and address those concerns. And then after that, which will be next year, or next May approximately, they'll vote on the DFCs, which then will go to Texas Water Development Board. They'll run their models, and they'll get the values back at the beginning of 2027. Okay? So there's a lot of input on the local level, and then also within the district level on the DFC processes. There's a lot of ability for locals to come in and say, hey, I'm not happy with this. You know, I think you're allowing way too much groundwater withdrawal. You need to scale that back, okay? So a lot of input available. So this is just kind of the recap, the joint planning and how it ties into the regional planning, which I didn't discuss much, but I just want to show how, you know, the GCDs come together on the GMA level. They decide on the DFC, which goes to the Texas Water Development Board, which then they come up with the MAG, which again, districts are required to manage to that MAG, that modeled available groundwater. And then that MAG value actually goes into the regional planning process. So it's kind of going up to the next tier. And then when regional planning is occurring and they're coming up with a state water plan, they know how much groundwater is available per each region of Texas to fit into what all the needs are of the state. So we get this question a lot about GCDs and oversight. So there's 3 different levels of oversight. The first one is obviously local. They're subject to public information requests and the Public Information Act. They're also open to Open Meetings Act. If you've ever been to a district meeting, you know, all of the meetings, the agendas have to be posted online. Budgets now have to be posted online, and a physical copy has to be present so everybody can see it. Board of directors are often elected. You can review a general manager. If somebody has an issue with a general manager, they can petition the district and say the general manager is not effectively managing the district. Moving over, we have legislature and judiciary review. So judicial review, districts can be sued for takings claim. Also, they get sued for other things as well, but the most often time they get sued for is they're limiting the production from a certain permittee, and they don't like it, and so they get sued. And then they also have to go through the legislative audit review process, and so districts are essentially randomly selected, and they go through the state auditor process and make sure that they're following all the rules and regulations that they need to follow. And then they have a lot of oversight by state agencies, again, going back to the management plan that they have to come up with every 5 years. Those have to be overseen by and approved by the Texas Water Development Board. There is a petition for inquiry process through TCEQ. So if anybody does not think that a groundwater district is managing effectively, they can petition for the TCEQ to review that. There have been several cases in the past couple of years where districts have been petitioned for various reasons. And then TCEQ can actually take away or recommend closure of a district if they're not effectively managing their resources. So lots of oversight for districts. So what else do they do? The biggest thing is science and data gathering. That's an extremely important function of districts. So Texas Water Development Board, they've got the ability to collect groundwater data throughout the state, and they've got a whole, you know, networks of wells, but obviously there's some areas where there's gaps. There's also areas where maybe they need a little bit more data, and districts fill in those gaps by, you know, taking money out of their budgets to put in maybe additional monitoring wells or doing a local study, try to figure out local hydrogeological conditions, which then they can use in their management plan to make sure that their rules are effectively managing those resources in that area. They do a lot of outreach and education. Not all districts have the ability to do that, but a lot of them that have the funds do it. They go to local schools, they have career days and informational days. They spend a lot of time and energy on that. They have irrigation efficiency programs, especially up in the Panhandle area. They'll work with their ag people, trying to get them to use more efficient water delivery services, you know, all the pivots, stuff like that. They put a lot of energy and resources into that. Some of them have rainwater harvesting programs where they'll either financially contribute to new buildings and the construction of rainwater harvesting systems. Some of them have just some information, but they do a lot of that. A few have weather enhancement. This is kind of a touchy subject depending on where you are, but there are some districts, especially out in West Texas and the Panhandle, that have weather modification programs that are, I mean, they're highly regulated through TDLR actually, and so they'll have some enhancement programs, and then just general outreach as well. So a lot of data sharing and you know, going out.
Are those enhancement programs, is that cloud seeding or is that something else?
Cloud seeding or hail suppression, yes.
Repeat the question.
The question was that cloud seeding? And then, yeah.
We have one online question about how can someone get a copy of Chapter 36? Can you repeat that too?
The question was, how do you get a copy of Chapter 36? Just Google Chapter 36 Texas Water Code, and you'll be directed to a state link that you can either download it as a PDF or just a website. So I suggest the PDF, and that way you can search it, you know, within it. It's quite long, and there's a lot of information in there, so it's good if it's in a PDF, and you can just hit Control F and go to exactly what you want to look at. So before we get, hopefully I've got a little bit of time, talk about TAG and what we do. Again, we're a membership organization. We spend a lot of time facilitating communication throughout GCDs. We host events throughout the year, including the Texas Groundwater Summit, which we just wrapped up last month. We bring all the districts together, both staff and board members, teach them all about what's new in groundwater in Texas, both on the science side and the policy side. We have a website where you can go to and get a bunch of information on districts, a lot of the information that I've included and talked about today. We have some handouts that you can take, some one-pagers. During the legislative session, we track legislation and any pending policy changes within the legislature. I spend a lot of my time talking to people up at the Capitol about groundwater and what needs to change and what's going on that's good. We serve as a resource to the districts, especially some of the smaller districts that don't have a lot of funding. We're able to help them out in a lot of different ways. I got invited here today because, you know, one of the local districts got invited. They couldn't make it, so I'm here instead. And then we also work with state agencies, Texas Water Development Board, TCEQ, and make sure that we're following all the rulemaking that's going on there that have implications for groundwater management, and make sure the districts are caught up on all that. And then we collect data on GCDs, which brings me to our TAG index. This is a very popular site. So again, there's 98 districts out there. All of them are different. It's one of the beauties about districts is it's local control, so all of their rules are tailored to the local needs, right? Sometimes that can be very confusing. So what we've done is we've compiled a ton of information on each district and have it in a easily accessible database on our website. So if you're in a particular area and you want to know information on a specific district, or you want to pull information on a bunch of different districts, say within the GMA, you can pull all that on our index. It has not been updated in a few years, and we are currently in the process of not only updating the information so that it's current, but we're also going to be adding a lot of new fields to the database. So we get a lot of questions, and it's information that we haven't previously collected. So we're going to try to capture all of that information that people have been asking us for. So very useful tool. And I have a few minutes left. I just want to take a couple of minutes to talk about Prop 4. I don't know if anybody of y'all have heard of this, but there's going to be a proposition this November. And essentially, last session, they created the Texas Water Fund, which is a fund that will fund water projects, infrastructure projects throughout the state. Last session, or 2 sessions ago now, The Texas voters approved it, and they funded it with $1 billion. This legislature, this past legislature, they passed HJR 7, which essentially would create a dedicated revenue stream to that Texas Water Fund for the next 20 years. It's $1 billion each year. I can't say vote yes or no because I'm a nonprofit, but I can say it is not a new tax. There's a lot of misconceptions about what the fund actually is. It is not collecting any new tax from Texas or Texans. Essentially what it is doing is just saying if we have a surplus in our budget, which Texas is blessed, we always have a surplus, 1 billion of that surplus will be guaranteed go into the Texas Water Fund for the next 20 years. And this will fund new water sources and aging infrastructure, okay? So if anybody asks what Prop 4 is, just tell them it's not a new tax and it funds all of our new water sources, which is essentially water sources that haven't traditionally been tapped into. So Texas has a lot of brackish groundwater. We've got a lot of produced water. We're along the seashore, so we have access to seawater, and that money would be accessible to projects that want to tap into those new resources. Also, we have severely dilapidated infrastructure throughout the state, especially the larger cities. In some areas of the state, we see like close to 80% water line loss. So a lot of the money will be going towards repairing that old system. So we won't have to rely on existing sources as much. So that's what Prop 4 is. All right, I've got 10 minutes for questions. Yes, ma'am.
Somewhat recently, Williamson County tried to either create a groundwater conservation district.
Yep.
I'm not really sure, but it was too expensive to run the election. What I'm remembering. My question is, if some of those blank areas of your map want to create a district or form another one, is there funding available to run the election? And does the Texas Water Fund that provide?
So the question was, if you want to create a district, are there funds available for the election of said creation and or, what was the other part? Okay. So two parts, Texas Water Fund could not be used for that. It's very specific what the Texas Water Fund can be used for, and that's not one of them. And then there are no funds that I'm aware of. My understanding, and this may be completely inaccurate, was they basically wanted to join the district that's here, the Clearwater Underground Water Conservation District, and they didn't have any funds to do it, and so the district here was going to have to pay like $1 million for the election, and they just could not afford it. Excuse me. So my suggestion, if you live in Williamson County and you want to get a district, you petition the TCEQ to do so. And then Williamson County would have to pay for the election. Any other questions about groundwater management in Texas? Yes. Excuse me. Yes. Karst, yep.
But there's also one not far from here, south here, that is sand-based. So anyway, it's much more susceptible to how many straws are stuck into it, and water going down to a depth where existing users have to re-drill very deep in order to reach it. And,
Yep.
and it's, apparently there's not very many drillers out there, and the cost is exorbitant.
Yes.
And they're building more and more to fit subdivisions around them.
Mhm.
They're going to try to use that water. So what does this exactly mean? How do they manage that?
Okay, well, that was a very large question. Basically, she stated that there's different aquifers around here. We have an issue with drillers, capable drillers with the equipment required to drill deeper wells. We also have an issue with people moving here and creating subdivisions. So many parts to that. One, yes, and we're blessed with a lot of aquifers, but a lot of aquifers are very different, correct? So that's one of the beauties of groundwater conservation districts and local control is because literally if you're in Bell County, you know, your aquifer may be completely different than next door in Burnett County, right? Or if you're in Travis County, go over to Lee County and the districts or the aquifers are going to be different. So you want to have a groundwater conservation district that knows the local hydrogeology and can make decisions on its management, right? So that's one part of the question. Yes, the second part is the number of drillers out there. This is an issue throughout the water sector, not just on the drilling side or the groundwater side, but just water sector overall. We see a lot of people aging out and leaving and not a lot of young people wanting to take on that role or get into this field. There are a lot of informational campaigns that are currently being started up right now to try to get more people involved in the water industry. Specifically on the driller side, it's a huge problem. One, because costs are extremely large to drill water wells, and the equipment required to drill water wells and the expertise needed to actually drill the wells is getting extremely high, or at least on the equipment side. The technical ability is not really changing, but
They have a right to do it, but they don't have the ability.
correct. Yeah, I meant a rig that costed, you know, $100,000 10 years ago is now like $1 million or, you know, even more than that. So, and another thing that you brought up is the water is deeper and deeper and deeper. So you need larger and larger equipment to get down to those depths. So that is another issue. Texas Groundwater Association has a lot of information on that. If you're interested in that, you can go to their website. But they've been talking about that for 10 years. So it is an issue.
Hi, my name is Mark. I'm on the board of Slaughter King Acres Water System. We're in South Boston. We have 100 taps. It's 100 customers. And the Barton Creek District has been squeezing us for the last 7 years to the point where we kind of don't know what we're going to do anymore. They've taken away we have historically underpumped. They decided, meaning we didn't use as much as we were allocated to the citizens. Our reward for that is they took it away. So, yeah, they also reclassified us. We were a tiny little water system. They bumped us another class with all of our fines and penalties stuff. Okay? We don't have any bad players. We don't have anywhere to go. We don't have a big mining operation that's wasting money. We don't have any of that. We are now unable to provide water without fines. It looks like. So we're going to add that in the restrictions for drought. Between taking away our overage restrictions for drought, we now have to are planning to be in drought and in being fine from now on. Because there's no way. We haven't got anything to go. The latest problem is people who don't care what their water bill is. Literally. No problem with $700.
Yep.
So that means deeper into fine territory. And what's happening around us is, talk about aging out. I don't get paid. None of us get paid. I don't get paid to go and yell at somebody for using water, but I'm the one that does it. But more and more of our compatriots are just being eaten up by companies. And there are half a dozen companies who will own all the water in Texas if this keeps happening. So it's important for you to know kind of what's going on, at this level. And we're in a real difficult position. We're trying to do the best we can, but it's really, really tough.
Yeah, and I certainly sympathize with you and your organization. Sorry, there wasn't really a question, so I'm just going to address it. You know, you're not alone. There are companies coming in that are buying up all the smaller utilities. There is some policy changes that have occurred, you know, additional funding for smaller entities. There was a bill passed this past session that allows for districts to really go after the people that are overusing, especially during drought times. They have drought contingency plans that they are required to create now and enforce. That was a big issue prior to this past session, was that you'd have issues with these people. They said, you know, they're under drought conditions, and they just say, well, I'm just going to keep pumping and you can find me. Well, what they did was they like severely increase the penalties for that. And not only that, but then they allowed for a judge to determine that if the company did it essentially to make money in times of drought, that they could be fined even more. So it gave districts and the ability them to get more money. Does that make sense?
Building inspectors get shot in Texas.
Oh, I know. I worked at TDLR for 10 years prior to coming to this job, so I was the one that was inspecting wells, so I fully know that. Yeah. We are a private property state, that's for sure. I think we have time for one more question.
I was just curious about, I heard that they're trying as a new or old method, storing water in the ground, like reserve water.
Yeah, it's called aquifer storage and recovery. So there is technology out there, and depending on where you are in the state and the aquifer that you overlie, there is storage potential there. Now, the problem with that is it's expensive to prove out. And you also have to take into considerations the quality of the water that you're injecting versus the quality of the water in the aquifer. If they don't match, you can get all sorts of reactions that occur that can plug up the well or contaminate the aquifer. So there are projects throughout the state that are ongoing right now and being tested. There's one in this area currently going on in Fort Cavazos that they've seen some really, really good results from, or that's my understanding of the project. So yeah, there is the ability to do that. But, Whitney?
Can you mention the Mountain Water Symposium on Wednesday, November 19th?
Yes, Wednesday, November 19th, the local Groundwater Conservation District is going to be hosting a symposium. They're going to have people coming and talking specifically about that project and also some other groundwater-related issues in this area. Also, districts throughout the state also have local symposiums or workshops where they'll talk about some of those local projects that they're undertaking or that they're a part of. A lot of districts can't necessarily, or they don't have the funds to undertake projects like that, like ASR or MAR, but they're heavily involved in the projects themselves because they're working with those entities to prove up the projects. And oftentimes they're, you know, giving them a lot of the data that they need for it. So I think I'm out of time. But I will be out here if anybody wants to come and chat with me. I'm going to stick around for a while. Thank you.